Okay, good afternoon, everyone. I think time has come to conclude, if there is anything to be concluded. Well, welcome everyone to this closing session. Nicholas and I have the pleasure to try to formulate some concluding thoughts on the theme, but also on all the very good stuff we've read and heard these last days. It's also the opportunity for me to thank the organizers for setting up what I believe was a very challenging and ambitious confidence. I'm also very grateful for their confidence in my ability to deliver something that resembles concluding remarks. And eventually I'm very happy to share this responsibility with Nicholas. Well, my intervention is supposed to be partly improvised. Of course, it's not entirely the case, simply because I read your papers these last days. I read the papers beforehand, and I must say that I was struck by the number and the quality of new ideas that I found in these papers, and I see this as a sign of great dynamism, and especially among younger scholars. And I think, and actually my enthusiasm was confirmed by what I heard these last days, and I must say, at least what I heard in those panels that I was able to attend, and I apologize for not having been able to attend all presentations. Well, so this dynamism and creativity which I've witnessed are certainly very comforting and very refreshing. And I would like actually to push, before getting to more critical remarks, I would like to push this praise a little bit further. I believe that many of the papers we've read, many of the presentations we've heard, actually epitomize the rise of a new generation of R2P scholarship. I think this conference felt very much, at least that's my take, it felt very much like the launch of a new groundbreaking generation of smartphone by a major manufacturer. I mean, I think to some extent this conference paved the way for sort of new generation of sophistication in the thinking about R2P. The first generation, which we know was this thinking about R2P, which was very much bred in the debate about the entitlement to intervene, and that was prior to 2005, and at that time R2P was more construed as an ersatz for humanitarian intervention. Then the second generation was brought about by the 2005 debates, and the idea then grew more multi-layered, and it was upgraded as to include a more preventive and restorative dimension. The original dimension was more reactive and interventionist. Well, this conference brought this growth of R2P to another level. I think after 2 days of work, my overall impression is that scholars here, or at least many scholars, are not necessarily advocating a move beyond R2P, as was indicated by the conference, by the conference title. No, I think what we've heard is more conducive to the introduction of a new generation of R2P scholarship. And so in that sense, I think this conference was more about introducing a new generation of scholarship rather than moving beyond classical R2P. I think we've seen more sophistication. Panelists have introduced all kinds of innovative features to the idea of R2P. I think Nicholas will dwell on this a bit further. The original reactive and interventionist perspectives are still there, but I think they've been complemented by all kinds of new features, new ideas, paving the way for what I see as a new generation, a new step in the development of the scholarship on R2P. Well, to be honest, this is as far as my enthusiasm will go. Innovation is not without pitfalls. Innovation, as you know, can spin out of control and brings us back to the Stone Age. And the point I want to make today is that innovation in scholarship, as illustrated by what we have heard these last days, cannot be pursued without some self-critical, some critical self-reflection about what we need, about what we do, about how we innovate our thinking, about how we sophisticate our doctrines. My ambition for the next 25 minutes is accordingly to raise some awareness about the mythological moves that permeate the sophistication of the scholarship that was presented these last days. And actually, more particularly, my intention is to identify 4 main methodological moves which international legal scholars dealing with R2P indulge in. And so my aim is to flag 4 main methodological moves, 4 main agendas behind R2P scholarship. Well, before I do so, very briefly, I appreciate it's Friday night, many of you have to take trains. I would like to formulate 2 caveats, 2 preliminary caveats. The first one being that besides reading with great interest all the papers, I also reviewed a bit of international relations and moral philosophy scholarship in connection with R2P. And I read many of these works that have been published in this journal that has now profiled itself for the receptacle of the scholarship on R2P, which is Global Responsibility to Protect. Well, against the backdrop of what I've read, I must say that it's nothing groundbreaking. It's fair to say that there are several doctrines of R2P. I think the thinking about R2P has grown very fragmented, and it's fragmented along epistemological lines. It is fragmented along the lines of disciplines, and I think that doctrines of R2P in international law and international relations, in political philosophy, in moral philosophy, are very alien to one another, and they're even very incommensurable. And I'm not sure, for instance, that the level of sophistication we've heard these last days would be something that international relations specialists could relate to. Or I'm not sure this is something that political philosophers would feel comfortable with. And I'm not sure this is something they could cognize and understand. So there is a great epistemological fragmentation in the thinking about R2P. Well, again, this is very elementary and is of course not surprising. I believe that once concepts have been floated, when concepts have been aired, they inevitably spin out of control. Once created, they proliferate and they fall in the hands of several different professions, and each profession molds ideas and concepts according to different techniques, different agendas. They bring these ideas in different directions. So, like any idea in social science, I think R2P was floated, and the authors, the fathers of the ideas just lost grip on it. And that's why the concept grew so fragmented, and this is what happened to R2P, and also the responsibility while protecting. I don't think that now the way it is now understood in the scholarship is really what the Brazilians had in mind. So great pluralism in the scholarship on R2P, which forces me to actually restrict my thoughts to R2P as it has been received, designed, construed and molded in international legal scholarship. And so I'm aware that the thinking about R2P is proliferating in other social sciences according to different methodological and methodological dynamics. However, I will just engage and indulge in some navel-gazing exercise. I will just speak about international lawyers and how they deal with R2P, and this was my first caveat. Second caveat is that I'm not going to reiterate the very strong and sometimes very compelling critiques that have already been raised against the 2 previous generations of R2P. I think some of the participants here have recalled and have even expanded these criticisms. I think they're well known. We've been, as you know, we've been talking about R2P. I mean, R2P, and I'll just recall a few of them. R2P has been criticized as a deceitful tool for regime change, as a doctrine of intervention in disguise. Some other people have bemoaned the fact that it was just the pursuit of one type of justice and that it was prejudiced as far as the type of justice it promotes is concerned. Others have argued that protection is not neutral, it's not a neutral concept, it's politically loaded. Others have said that actually R2P tend to privilege certain kinds of institutions and certain forms of action over others. Other scholars have said that it's not going far enough, that its scope, ratione personae, is too narrow, it should include other actors. That's something that's been discussed these last days. Its supposedly soft law character has been also bemoaned. I personally believe that the problem is not the soft law character, but the problems are much more structural, but I'll come back to that later. Others have said that R2P comes with double standards, it's too African focused, that it's not universal. Others have said that R2P claims are exaggerated. The novelty of R2P is exaggerated, that many of the normative standards that it tries to put forward are already enshrined in positive international law, and these people refer to the Geneva Conventions. Others make the opposite claims that actually R2P bring about a regression about the standards already in place, especially when it comes to the Geneva Convention. Again, and I can go on and go on, others have said that have taken aim with the Kantian nature of the R2P project and described it as moral internationalism, a sort of new realism, that's the unorthodox criticism, and so on and so on. And I think one of the most compelling critique is the fact that R2P does not do away with the problem of justifying authority altogether, and that's, I think, one of the most compelling critique. But all this is quite well known, and this is certainly not what I want to dwell on. I think my point is rather epistemological, it's rather methodological, and as I said, I want to offer some thoughts on what I perceive to be the four main agendas behind R2P, and behind each of these agendas there are actually four methodological moves. So the four methodological moves, the four methodological agendas behind R2P. So I'm going to map a little bit with a few critical thoughts. I can't resist. These four main projects behind this overarching thing, which is called R2P. And as you will see, that these methodological moves are not completely groundbreaking. These are moves that have been observed with respect in connection with other concepts in international law, in connection with other research projects. So they're very reminiscent of moves and constructions we've seen elsewhere, and in that sense, what I'm going to say is not at all groundbreaking. So four methodological moves, and this is not exclusive of others, but the four agendas which I believe are worthy of mention here are first what I call the regulatory agenda, which is something we discussed this morning in the panel on non-state actors. There's also the explanatory agenda, the compliance agenda, and then the epistemological agenda. So these four agenda: regulatory, explanatory, compliance agenda, epistemological agenda. And let me just say a few words about each of them. And as you will see, each of them manifests itself in very different ways. So they're very multi-layered. And my view is certainly not to hide the complexity and the multi-layeredness of these methodological moves. Let's start with the first project, the first agenda which I see behind R2P scholarship. Well, the first one is regulatory, and that is the idea that R2P operates at the level of the creation of primary and secondary norms of international, something we alluded to this morning. Well, first, R2P can channel the creation of new primary norms, and in that sense, something we discussed, R2P allows to bypass the theory of sources and to make standards binding, standards which otherwise would not have been deemed binding by virtue of the classical theory of sources. It allows the expansion of the scope of application of certain norm. It allows to bypass the problems of subjectivity, the idea of legal capacity, legal personality. So this is what I call the regulatory projects behind R2P, at least when it comes to the creation of primary. In this sense, using R2P in this way actually can take several forms. You have first what I would see the direct law-making route, and that is the idea that R2P generate primary norms, and that is the idea that R2P is a law-making technique in itself. That's something rather isolated. I think very few international lawyers would go down that route. There is then the indirect law-making route, and that is something I mentioned this morning, the idea that R2P will bring about an adjustment of the theory of sources with a view to allowing the emergence of new norms. And eventually there is the interpretative route. The emergence of new norms will be achieved through interpretation, and in that sense R2P will be elevated into a sort of magic interpretative standard. Well, so construed, R2P emerges an extremely efficient and convenient item for scholarly, extremely interesting and efficient tool for scholarly innovation and for progressive development of international law. It is by virtue of this approach that R2P helps generate all kinds of new obligations for states. And here I'm just mentioning what I've read. There is this general idea of positive obligations of states, obligation of prevention, due diligence. These are the usual suspects. There's the obligation to criminalize, the obligation to motivate one's veto, the obligation to introduce new international crimes. This also helps generate new obligation for non-state actors, which otherwise would not be bound. This regulatory understanding of R2P helps to provide some flesh, some substance to provisions which otherwise would be non-normative, and I'm thinking here of Article 1 of the Geneva Convention. So R2P can help provide or reinforce the substance and the guidance which is found in some existing international law. R2P, so construed, can generate codes of discipline, self-restraint in the exercise of institutional privileges. It can give procedural obligations. That's the theory of Anapetas. It can even justify institutional proliferation. In the literature, I found the idea of an R2P Council, I found the idea of an R2P Commission, I found the idea of a Human Protection Council. All this is informed by this regulatory framework, this regulatory project behind R2P. So it's a very, in that sense, it comes as an extremely convenient and easy gap fill, a banner under which international law can be progressive, can be developed. And this is again very reminiscent of self-determination in the post-colonial era. Self-determination has long been a banner under which many agendas, many progressive agendas have been carried out and vindicated. Well, this is as far as the creations of primary norms is concerned. R2P can, in its regulatory fashion, can also be very instrumental in the creation of secondary norms, especially when it comes to accountability and responsibility. And very often what you find in the literature is that R2P is aimed at the reinforcement of the rule of law. R2P is a responsibility channeling mechanism. And this, in that sense, and it really is conducive to the reinforcement of the international rule of law. And it does so in many different ways. Either R2P allows the behavior of classically non-justiciable actors to be anchored in state behaviors, to be attributed to the state, either by attribution of conduct or attribution of responsibility. It also allows the design of new framework of responsibility for actors which classically were left outside of the mainstream conceptual frameworks of responsibility. It also helps to actually modernize international criminal law. It is an umbrella under which international criminal law can be adjusted and new crimes created. This is also something we have heard these last days. So that's the first agenda, the first move, the first functional move behind R2P. Probably it's one of the most common. I think this agenda calls for two brief remarks, very brief, before I turn to the second move, the second agenda. Well, there is first a a remark about customer international, because in this quest for this regulatory quest, this quest for the regulation of these grey areas, these black holes which seem to escape international law, well, customer international law is often seen as I said, as a silver bullet. It is a very convenient tool to expand the remit of international law. But in this respect, I would just like to say that when it comes to R2P, customer international law is actually both the ally and the enemy. It is the ally because, for reasons we all know, it creates a sort of comfort zone where all kinds of innovative obligations can be created, can be generated, and that's thanks to the very structured, deformalized structure of customer international law. But customer international law can also be the enemy, or it can also be a barrier, because despite what I see as its methodological generosity, customer international law does not always allow to deploy the full thrust of R2P. And for instance, I think very often customer international law, the theory of customer international law in connection with R2P is misused. There is this whole idea that by elevating a rule into customer status, this will expand the scope of application. And there's this whole idea that even the RCRC or the RCTY buy and embrace, that this idea that because the norm is customer international law, it automatically applies to new situations like non-international armed conflict, or it applies to new actors. I think that's not a change of the nature of the rule, that's a change of the scope of application. And so, in that sense, customer international law is not always as convenient, the convenient ally, the convenient friend of R2P theory, and I think it's the object of much abuse, very often because people change the scope of the rule under the guise of a change of the nature of the rule. First remark. Then there is a fundamental problem with the idea of R2P as a customary rule itself, a customary rule itself which would generate other customary rules. Well, I mean, I doubt that a norm without substantive flesh can turn into a customary rule. I think the question of the crystallization of R2P does not even arise. The issue is not crystallization. The issue is to give substance to these vague standards. It seems that the international legal scholarship has turned very oblivious of the International Court of Justice and the old continental shelf case. We have all forgotten that the reason why the continental shelf case, the reason why equidistance was not accepted as a customary principle was not because lack of practice, lack of opinion juris. It's simply because it was a non-normative principle. The standards was too vague. I think the exact same objection could be raised against R2P. I don't want to sound too legalist. I believe the theory of customer international is a huge problem, is hugely deficient, as I've written somewhere. But from the moment you abide by this theory, just then try to apply it properly. And if you apply it properly, the question of the customary nature of R2P does not even arise. The issue is not crystallization. The issue the matter is fleshing out the standard. And as long as the standard has not been fleshed out, there's not even a question of customary status. And the same was, and again, nothing new. The same, we witnessed the exact same problems with self-determination. Before it was turned into a decolonizing norm, there was nothing, the question of the customary status of this self-determination did not even arise. It's only after this dramatic night of December 1960 that the idea of customary norm of self-determination arose. Well, that's enough for the first agenda. Be assured there'll be much shorter for the three others. So first agenda behind R2P, the regulatory agenda. Let me turn to the second one, which is what I call the compliance agenda. And here the idea is that R2P operates at the level of decision-making processes. But in the literature, lots of authors construe R2P as a compliance-enhancing mechanism. I've read in one of the papers, Mrs. Richford, it's an exercise of persuasion. And I think that captures very well a big chunk of the literature. In that sense, R2P is a violation preventive mechanism. It's there to trigger, to bring about more maturity, and actually I'm using the words I've read in the literature, and bring more maturity in the international legal society. It is a sort of all-encapsulating discourse that is conducive to better compliance by states and international organizations. It's a narrative that bolsters compliance with IHL, with international human rights. In that sense, it is a sort of Kantian narrative meant to shore up the consciousness of states and international organizations. Well, this is quite mundane, this is quite common, and I don't think it calls for any additional remark. This is quite well perceived by most of us. So I turn now to the third agenda, which I believe is slightly more intricate, and that's what I call the explanatory agenda. And here, actually, R2P operates at the level of cognition. R2P is all about how we cognize and understand the world we live in. And here, actually, this explanatory function, this explanatory framework of R2P manifests itself again in different ways. And the first ways, and the first manifestation of that is the scholarship according to which R2P is an unifying conceptual tool. It is a defragmenting tool. It is a sort of glue for conceptual unity. It defragments basic and unify basic dichotomies, paradigmatic dichotomies in international law. Actually, it even do away with fundamental dichotomies on which the international legal system was built. It allows to bridge very alien concepts, the domestic and the international, the state and the non-state, the territorial and the extraterritorial, the legal and the non-legal, the international nature of armed conflict and the non-international nature of armed conflict, the sovereignty and the intervention, the inside and the outside, and here it is unlawful, the nation states and the international community, the us and them, says unlawful. So that's what I see as the defragmenting and unifying conceptual role of R2P. R2P can actually even more fundamentally be a tool to make what I again call commensurability. It link concepts which are completely alien to one another. It is a very convenient concept to link self-determination, legitimacy, responsibility, universal jurisdiction, sovereignty. They all reconcile in the wink of an eye. And suddenly all these concepts, which are very alien to one another, are actually they come to be mutually enriching sister concepts. And so R2P allows to create kinship between all the system, between all the concept of the international legal system. And in that sense, it really expresses a quest for unity of the system. Still, as from the perspective from an explanatory perspective, R2P is also a sort of tool for a better explanation of a wide range, a better elucidation of a wide range of practices, and all these practices magically are channeled in the concept of R2P. R2P in that sense elucidates complex practices. I mean, any practice that is geared towards a humanitarian end comes to feed in. Let's say practice of Libya and Mali, Côte d'Ivoire, which are very often commented upon in the literature, are reconstructed as new practice of R2P. And actually, this move is not only an explanatory move; it is also a reconstructing move. All this practice, which is apprehended through R2P, is also reconstructed as R2P practice. And in that sense, R2P is actually not only explanatory, but it's also generative of new practices. It allows the creation of new phenomena, and it allows the creation of a whole new world, which can then be studied according to the paradigm of R2P. And for instance, it creates one type of injustice, which then international law is supposed to fix. It creates one type of crisis, which international lawyers ought to address, and this is very exclusive of all the other types of crisis of injustice that could be created and cognized in this world. So there is a lot behind this agenda, behind the explanatory agenda. There is a lot of self-referentiality. R2P creates its own practice, which it then channels into its conceptual and paradigmatic framework. And this construction of a whole new world is made possible by virtue of very loosely defined conceptual paradigms. And that's because R2P is not formally defined, or at least its paradigms are very, very vague, and this allows many things to enter and to be swallowed by R2P. And in that sense, R2P reminds me of global administrative law, which is also this all-embracing enterprise, which is made possible by very loosely informal paradigms. Well, that's as far as the explanatory agenda is concerned. And the explanatory agenda actually brings about a self-referential generation of practice. Then I turn to the last project, the last agenda, which I perceive behind R2P. And here, actually, R2P operates within the profession of international law. And here, the epistemological agenda is actually geared towards a rehabilitation of international law as a profession. And I believe this is the most fascinating part of the R2P project, and this is what I had kept it for the end. It is something where, by virtue of which an entire profession tries to rehabilitate itself and rehabilitate its object of study. And one way in which R2P serves as a professional rehabilitator is, and that's something Nicholas will speak about, is the extent to which R2P tries to rehabilitate the Kantian project of international law. It also tried to rehabilitate the constitutionalist project by seeking to anchor constitutionalism in modern conflict, by seeking to enhance the practical impact of constitutionalism. In that sense, R2P comes as a sort of enforcement arm of constitutionalist theories of international law. It's also a sort of rehabilitator of the human rights project. And of course, behind it, there's all kinds of presupposition. It presupposes that the human rights project has failed. It presupposes that constitutionalism has failed. It presupposes that the Kantian project has failed. And I think that's a first type of epistemological move that can be perceived, that can be unraveled, that can be flagged when it comes to R2P. Another one is R2P as a sort of, and it's nothing new, as a sort of smoke screen for interdisciplinarity. I think like other concepts international law have designed, like soft law, R2P obfuscates the interdisciplinarity in which international law is engaged. It is a sort of smoke screen behind which international lawyer can study the dirty politics, but still call it international law. And that's something we don't need to discuss tonight, but this is something that originates in this unease of international lawyers to study a phenomena that cannot be properly labeled law. And it brings us back to this old question, why can't we study a phenomenon without necessarily calling it law? But at least the point I want to make is that R2P to some extent serves as a smoke screen for interdisciplinarity, which is kind of ironical when you know the origin of the concept that was not created directly by an international lawyer. Well, R2P still in this, according to this epistemological rehabilitating framework, R2P can also be construed as a sort of self-legitimizing tool to revisit a very mundane and traditional topic. I mean, it's a platform to revisit very old mechanisms and rules. It's a tool to inject some freshness in otherwise rather mundane and well-known rule. And I'm just mentioning a few: humanitarian intervention, diplomatic protection, humanitarian law in general, traditional case law, the idea of hierarchy, use organs, extraterritorial application of human rights, due diligence, protection of national growth, even dead provisions like Article 43 of the UN Charter, protection of civilians. All these are traditional topics, and R2P gives international lawyers some legitimacy to revisit them while still producing fresh and innovative scholarship. R2P, still in this slide, can be seen as a very self-reproducing conceptual project. And R2P regenerates itself from within. R2P is generative from within of new concepts. R2P calls, and so it allows a profession to generate new concepts of study. And I can just mention the idea of national authorities. I read judicial humanitarian intervention, military responsibility, responsibility to rebuild, economic self-determination, then all sorts of new crimes. And so R2P generates itself new objects. It's self-generative. It generates by itself new objects of studies. It also does so by perpetuating the old nightmares. This what I think is a journalistic idea, this idea of sovereignty. And so sovereignty is perpetuated as if it had ever been around. Sovereignty is made the villain. It's made the sources of all evil, and it is consolidated. So R2P actually functions a lot with strawmen, and therefore it also generates its own insufficiencies, and that's actually the most ironical thing behind R2P is that R2P generates its own insufficiencies, calling for new concepts to be created to address the insufficiency of R2P. Something I've been discussing with some of you today. And so it makes the scholarship on R2P makes R2P deficient to make it in need of a bailout. And who is responsible for the bailout? Of course, the international lawyer. And that's how we came to this idea of responsibility while protecting. And so we become slave of our own concepts, and we then bound to rehabilitate them. Well, and on this, in this respect, I think my bet is that for the next 5 years we'll be busy with responsibility while protecting, and then the next 10 will be busy with human security, which is all self-generated. And in that sense, I think R2P operates like a hamster wheel, spinning a bit unbound, the hamster running endlessly in the wheel and amusing the kids in the room. Last but not least, be assured, R2P still, according to this rather epistemological, from this epistemological perspective, operates as a self-empowerment of international lawyers. R2P is actually a linguistic de-sophisticator. It actually simplified the language of international lawyers and allowed them to speak the language of world politics. It is a sort of linguistic therapy which fixed the inability of international lawyers to speak the language of the powerful. It is a sort of branding that the international lawyer used to be heard in the international arena, and it is an attempt to lend the legitimacy, the authority of international law to other actors. But the thing is, by lending it, you keep control. You keep control. So in that sense, I think R2P is a sort of self-empowering move by international lawyers who want to have a say in world politics. Again, nothing new. New Haven, the policy-oriented school of international law, was all about this. It was about empowering the international lawyers to give him some clout in Washington and the Department of State. And it's true that in this respect, R2P seems to have been quite successful. It has impacted the narrative of world leaders. And I think many papers here have recalled how it has been used by the Security Council, has been by the General Assembly, and so on and so on. And somehow any invocation of the narrative of R2P seems to be a step towards the empowerment of the international lawyers. Any invocation, it seems, as a victory. It seems to vindicate the rise to power of international law and therefore of international lawyers. I mean, in my view, I think the success behind any invocation of R2P should not be celebrated too quickly. It should not be overblown. I think we shouldn't forget that very often, by virtue of R2P, the success of an action is not vested in political determination or diplomatic genius. It is vested in the principle. And so in that sense, I think R2P comes to hijack political debates, and it observes political and obfuscates political success. I think courageous leaders are not recognized for their actions or political courage, but for the narrative they embrace. And I think in that sense, the epistemological, the self-empowering move behind R2P can be very counterproductive. Well, these are the 4 agendas, and I'm reaching the end of my contribution. These are the 4 agendas which I see behind R2P. Well, where does that lead us on this late afternoon Friday night? Well, here I come to the concluding remarks of my concluding remarks. Well, craftsmanship, innovations are all very noble, very welcome. It's a sign of freshness, it's a sign of dynamism, and in that sense I praise the panelists of the last days for their creativity. 2 qualifications, however. First is that, as I have tried to demonstrate, innovation is not neutral. Be aware, innovation comes with a political project, innovation comes with an agenda, innovation comes with certain methodological moves. And so my first point is simply that be aware. I think if you were to indulge more in R2P scholarship, just do it with awareness for the methodological moves behind it. My second point is that this sort of creativity we're witnessing in the scholarship on R2P should not turn pathological. I think it should not be pursued pathologically. Remember the metaphor of the hamster. If the hamster wheel spins unbound, the hamster will die and the kids will cry. So there is a risk behind this unbound, this endless creativity. What does that mean in epistemological terms? Well, this overwhelming appeal of R2P is not without epistemological risk. And these epistemological risks are things we've already witnessed in the past with respect to other very appealing concepts, and it suffices. I mentioned already self-determination a few times. I think this spell of R2P is also very reminiscent of the spell that was cast by Tsagourias on earlier generations of international legal scholars. And in this respect, I can't help mentioning Andrea Bianchi, who spoke of the magic of Tsagourias. Well, when it comes to R2P, I want to qualify a little bit the parallel with the magic of Tsagourias. I understand the appeal, the epistemological appeal of R2P, less as a magic spell, but more as a hallucinogenic spell. And let me explain this. I think R2P is not like magic. I think it's more like magic mushrooms. In my view, R2P makes international lawyers believe they can fly. It emboldens international lawyers to circumvent all their paradigms. And it leads international lawyers to lose any awareness of their methodological moves. Of course, I'm very prejudiced in saying this. Although I'm working in the UK, as you may know.
Because you're coming from Amsterdam.
I live in Amsterdam, and I must say that every year several dozens of people in Amsterdam die because they took magic mushrooms and believed they could fly and jump out of the window. Well, what does that tell us is, contrary to the impression my remarks may convey, I'm completely agnostic as to where to bring the debate. I'm moving beyond R2P or embracing a new generation of R2P. I'm agnostic. My only point, and this is my last sentence, my only point is simply that enjoy the R2P magic mushrooms if you wish, but just make sure you handcuff yourself to the table when you do so, so that you don't jump through the window after a few takes. Thank you for your attention.
Well, I think it's very difficult to add anything actually, because Jean has given, well, it was tour de force actually, and of the whole concept of responsibility to protect. What I would try to do is to make some comments and observations on responsibility to protect, which are, I think, would reflect what has been discussed in the course of these 2 days. And from the papers, what I can see is that they consider the responsibility to protect as a very important doctrine and or concept, and a very expanding one. So it expands to international criminal law, state responsibility, environmental law, corporations, etc. But this presents responsibility to protect as a self-contained regime and self-reproducing regime. It's exactly what Jean was saying. But there is reason why the responsibility to protect is a very appealing concept. And it's very appealing because it contains a promise, and people like promises. The promise is that the state is not going to attack its own people, and if the state attack its own people, then the international community will intervene to prevent or stop such attacks. So the responsibility to protect creates a notion of cosmopolitan citizenship, where people are not only citizens of their own state, but they're also citizens of the international community, and the international community is guaranteeing this citizenship. So the responsibility to protect extends social contract theories that justify the creation of the state, that the state has certain obligations towards its own people, to the international level, with the international community being the guarantor of this social contract. Also, we heard that we have the institutionalization of the responsibility to protect, and indeed, after 2005, with the World Outcome document, we have the normalization and also the institutionalization of the responsibility to protect. With normalization, I mean the acceptance of the concept of responsibility to protect by the community of states. And the institutionalization is that the concept has been integrated into the international, institutional, and legal order that is represented by the United Nations. This is very important because the concept of saving people existed before, but it was in a completely different form. It was in the form of humanitarian intervention. And according to humanitarian intervention, we have certain states that they were claiming that they represent humanity's conscience, and then they were intervening in another state to save people that had been attacked by their own government. So when NATO intervened in Kosovo, they claimed that they represent the international community and that they intervened in order to save Kosovars and to avert another humanitarian catastrophe. But this kind of intervention was unilateral and also was non-systemic. But with the responsibility to protect, with the normalization and institutionalization, this kind of intervention is accepted. But with institutionalization, the downside is that there are certain limitations on the responsibility to protect. Now, the first limitation is that the responsibility to protect is triggered only when there is massive violence against people. So there should be genocide, crimes against humanity, war crimes, and ethnic cleansing. Now, lesser forms of violence or human rights violations, they do not trigger the responsibility to protect. Secondly, with the attachment of the responsibility to protect to the UN system, and in particular to the UN collective security system in relation to the third pillar, the action in order to protect people, the responsibility to protect is subject to the discretionary powers of the Security Council and, of course, the right to veto. Now, since 2005, the responsibility to protect has been clarified and developed, but there remain areas that they need further clarification and development. So I will identify these areas. The first is the status of responsibility to protect. Now, we use different terms, concept, principle, norm. Then we say it's customary norm, it's an emerging norm, it's a soft law. Phraseology is very important because there are different consequences. A concept is an idea, a principle is a standard, which one can break down into specific modes of conduct or specific rules, and a norm is specific prescription or prescription. So the status is a very important issue. Secondly, there needs to be a better definition of the crimes that trigger the responsibility to protect. Now, Western states accept for crimes against humanity the definition contained in the ICC statute, but Asian states, or most Asian states, are not parties to the ICC statute. So they may have a different definition of what are crimes against humanity. A third issue is the relationship between the different pillars. Of course, the chronological sequence has been rejected, and now we can talk about logical sequence. And we have the responsibility while protecting. Of course, the question is whether the responsibility while protecting facilitates the realization of the responsibility to protect, or is an obstacle. To my mind, is an obstacle. But also with regard to these different actions, the question is what are the limits of each action under the different pillars. Another issue is that it is not clear what type of state is the ultimate aim of the responsibility to protect. Is it a democratic state, a state that respects the rule of law and that raises questions about democratic intervention or democratic reconstruction of states? Related to this is the relationship between responsibility to protect and regime change. Now, regime change has negative connotations, and in particular because it has been used by the neoconservatives to justify the intervention, the invasion of Iraq. The Libyan intervention has been also criticized that it exceeded the authorization of the Security Council and that the aim of the intervention was a regime change. But historically, severe human rights violations have been stopped by changing the government, either by internal groups or through external intervention. If you take the case of Rwanda, the genocide in Rwanda stopped when the Tutsis, who were the victims of genocide, took power. Take the case of Bangladesh or Cambodia. The crimes or the killings committed in those countries stopped because of external intervention. The role of states and regional organizations in implementing the responsibility to protect is another issue that needs to be clarified. Now, the 2001 document included states and regional organizations as residual actors in implementing the responsibility to protect. The 2005 document does not mention that. Subsequent documents by the Secretary General mention regional organizations. Now, if the responsibility to protect is a universal concept to which all states partake either individually or as members of international organizations, then more consideration should be given to their role in realizing that concept, in particular when the institutional system fails. Now, institutions or constitutions are not suicidal acts, and then they should offer safety valves to achieve the aims of the institution or the constitution when the formal decision-making processes fail. Another issue that needs to be clarified is what is manifest failure of the state to protect its own people, which is what triggers the third pillar under the responsibility to protect. And there is no clarification of that issue. Institutional reform is another issue. Now, the institutionalization of the responsibility to protect brought it within the UN system, and of course the discretionary powers of the Security Council. So the promoters of the responsibility to protect also advocate changes or reform in the membership and the decision-making process of the Security Council. However, proposals for reform triggered by the responsibility to protect need to take into account the broad remit of the UN collective security system and the multiple functions of the Security Council. Responsibility to protect is one element of the Security Council powers and functions. It's not everything that the Security Council needs to do. That leads to another issue, which is the place of the responsibility to protect within the international legal order. For some people, the responsibility to protect is the alpha and omega of international law. But I think this is an exaggeration. The responsibility to protect is an international law concept that exists, operates, and often clashes with other international law concepts. For example, when you have mass atrocities and the question of saving people arises, then the responsibility to protect offers one route to saving people. But in addition to that, you can have the concept of necessity, or the principle of necessity, and also you can have humanitarian intervention as an independent entitlement to action in order to save people. Now, what does this say about the place of responsibility to protect, or what does responsibility to protect say about the international constitutionalism, or about the international constitutional order? First, it confirms a reading of international constitutionalism as being based on common values and interests, which forge sentiments of solidarity and shared responsibility. But on the other hand, the responsibility to protect does not override the principle of sovereignty. It is states that agree not to attack their own people. It is states that agree that the international community can intervene when they fail to protect their own people. And any action by the international community is based on state consent in the Security Council. Secondly, it confirms another reading of international constitutionalism, according to which the individual is the center of international law and policy. Yet, no standing has been granted to the individual in the normative process. The individual still remains disenfranchised within the responsibility to protect, and the dominant force is still the state. Another reading of international constitutionalism that derives from the responsibility to protect is that international constitutionalism is supplementary to state constitutionalism in the way that it sets standards to which national constitutions are expected to abide with, and according to which state action can be assessed and evaluated. And also that citizens of the state can appeal to the international community when their rights are violated by their own state. However, this aspect is triggered only with regard to massive violations of human rights and only in extreme cases. So this indicates that international constitutionalism is a very uneven and very unsynchronized process. It is the product of the long process of accretion, where you have values, principles, or norms which are added onto existing values, principles, and norms, but there is no integration of these principles. So the responsibility to protect, in a way, is an additional principle which sits on existing principles, and often that leads to clashes between these principles. So I share a lot of the criticisms on the responsibility to protect, and personally I would advise also more people to be more cautious when they use a very expanding notion of responsibility to protect. And someone should never forget that responsibility to protect is not everything that international law has to offer. There are other areas of international law which are equally important, and they can operate in parallel with responsibility to protect. So these are my comments.